Death is your responsibility. Think about it. Before, during, and after your death is your responsibility. No one knows what you're thinking. And if they do, are they the executor or the administrator of your estate? Are they your power of attorney? Do you even know the difference between a will and a living will? The Pew Research Center did a study. They found that 32% of people have a will and only 31% have a living will. There are a lot of things that you can do to help prepare your administrator or your executor to manage your estate. There's a lot of different decisions that have to happen if you become incapacitated and directly after you die. And those vastly differ from the ones that come when they receive your death certificate. Now, what is the difference between an administrator and an executor? An administrator is appointed by the court in the absence of a will. The executor is the person you appointed in your will to handle your estate. So basically, you get to choose your executor, and the administrator is appointed by the court, and they are your next of kin that is at least 18 years of age. What can you put in the will? You might think you don't have a will, but anything that you own of value is your estate. The car that is under your name, the bank accounts that are under your name, the pet you have, the belongings in the place that you reside. The purpose of a will is to make it easier on them, knowing where to disperse these things and to make sure your cat gets taken care of and they think of you when they look at them. Now, what if you have children? According to a 2025 research noted by Neptune, 36% of parents with children under the age of 18 have wills. Now, just as you can appoint an executor in your will, you can appoint a guardian for your child. It's best to appoint a backup as well. Now, if you don't appoint a guardian, the courts have full disclosure over where they will send your children. If your family disagrees, they can obviously dispute it with the courts, but that's a long, lengthy, expensive process that puts your kids in a very unwanted position. Now, what is a living will? A living will is a will you can put in place for yourself in case you become incapacitated and can't make medical decisions. This just really helps that person make decisions knowing what you wish, and it keeps your family from disputes on what they think you may or may not have wanted. It's obviously uncomfortable to think about. How do you go about creating these wills and making them legitimate? It's a lot simpler than you might think. Before I say what you can do, the state of North Carolina does not accept audio or video wills as legit wills. All you need to do is type up your will. That's it. You might have to do a little research, but you just gotta type it up. Now, how do you make it legitimate? You have to have 2 witnesses alongside of you. They cannot be related by blood, they cannot be related by marriage, and they cannot have any financial gain from your will. You need to sign it, they will watch you sign it, and then they will sign it themselves. If you want to make it ironclad, you could have a notary there to notarize your 3 signatures. According to a Legal Shield study, 72% of people are scared away from estate planning because of their perceived price point. It only costs $30 to have a notary notarize 3 signatures. It's not free, but it's a lot cheaper than you thought, huh? Now, what happens after you're gone? There is a period between life and death, and your celebration of life, and I like to call it purgatory. I call it purgatory because your executor knows exactly what's coming, and they can't do anything with your estate until they receive the death certificate. This is where your planning comes in handy to handle the probate process. Whether you name an executor or the court appoints an administrator, your will is their blueprint for all coming decisions. This is a whole process that takes about 20 months to complete. According to PR Newswire, only 2% of the population believed it would take that long. If they don't have the means and you can't appropriately plan for them to have a lawyer in this time, they will have to file your will alongside your death certificate with the court, close your bank accounts, call your insurance companies, inform the Social Security Administration. They will have to set up an estate account to manage funds and pay off debts. They will need to publish a notice to local newspapers to give them notice to collect their debts. After debts are settled, then you can disperse the estate to the appropriate channels. And they will also have to file your taxes for that year. As intimidating and hard as this process is, being prepared minimizes that. And if you take time to sit down with the people that are going to handle this, it can even bring you closer. And then it gives you knowledge that you can then go and help other people plan for their passing. In the end, estate planning might be about you, but honey, it's not for you. It eases the sting for the executor. It allows them some areas to be able to breathe and grieve you in the monstrous process that is handling an estate. Your will gives your executor a blueprint of all the decisions that they will have to make. You might not tell them everyone, but they will then have a good idea based off of what you previously said, as well as your own comfort knowing the designated places your things will be going. Your living will gives you the opportunity to have a choice in what happens when you are incapable of doing so. It gives your power of attorney the knowledge to know this is what you wanted. And in the end, this planning makes the weight on your executor's back that much lighter. And it gives you the opportunities to help others and know what's to come. The estate process is a lengthy, intimidating, and exhausting process, planning. And planning for your spouse, your children, and your close circle, it eases their grieving. Never underestimate the power of a good plan.